The most frustrating part about your case, Josie, not only that you engaged in this kind of conduct to begin with, but there's those underlying issues that the court and other parties can understand, the substance abuse, okay? But the most frustrating part is how you would come to court, then you abscond and go away for a long period of time. Then you'd come back and say, Judge, I'm going to be better. I want to work this out. And then you'd disappear again. And then you'd come back and say, Judge, but really this time I really want to. And then you'd go and you disappear again. But hopefully you're on your path to figuring it out. Because if you don't, with all of the things that are going on, Josie, both what you're displaying outwardly, but most importantly, what you're feeling and going through inwardly, it's going to destroy you. We will go on the record in the matter 23 CF 92 26. Nope, that's it. 92 State of Wisconsin versus Joseph, also known as Josie Smith. Josie, you may come up here and have a seat. Josie appears in person in custody with counsel Joel Feliski. The state appears through District Attorney Kevin Schmidt in person. We're set for a sentencing portion of this case. There's been an extensive, significant delay in this matter from the beginning to finally the end. Josie, there were multiple times in where I would define it as you absconded. You failed to appear for court for very lengthy periods of time. A lot of money had been forfeited to the county, which would be at your expense because it was a lot of cash. I'm not even sure if we have any cash still posted, but the clerk will let me know during the process of this hearing. You pled guilty way back on November 20th, 2025. The court ordered a pre-sentence investigation report for those two felonies. One is a second-degree recklessly endangering safety, Class G felony, and the other felony is vehicle operator, flee or elude an officer. The court has received and reviewed the pre-sentence investigation report. Again, that took a lot of time and effort due to the fact that it was ordered. They weren't able to get a hold of you. You didn't contact them. You absconded. And that happened at least on 2 occasions that I can recall. Mr. Schmidt, did you receive a copy of the pre-sentence investigation report?
I received it. I reviewed it. I have no corrections.
Did you receive a copy of the sentencing memorandum filed by defense?
Yes.
Okay, Mr. Feliski, did you receive and review the PSI?
That is correct, Your Honor. I reviewed it with Josie, and we do not have any corrections to make at this time.
All right. Josie, did your attorney go over that document, this one right here, this big, thick document with you thoroughly?
Yes.
And you could not find any material errors that would need to be corrected?
No.
Okay. All right. So I'm going to start with you, Mr. Schmidt, sentencing recommendation and argument.
Thank you. State's going to be recommending the court follow the Department of Corrections recommendation. The court should order 1.5 in, 2 out on the fleeing, should order 3 in, 4 out on the reckless. Those counts should be concurrent to each other because they were part and parcel of the same action or series of acts on the same day. They described the same conduct. They should be consecutive to any other sentence in Wisconsin or Minnesota because they are distinct acts in a distinct state. I start first with explaining why probation should be rejected. First off, this is Smith committing their 3rd fleeing offense. They have 1 prior criminal conviction for it and 1 prior adjudication of delinquency for it. This offense was committed while on supervision for one of the fleeing offenses. Probation is a consequence for a crime that you're already on probation for and you do it again it's nonsensical. That is the clearest sign that probation unduly depreciates the seriousness of the offense. Furthermore, Smith's history clearly demonstrates that they're just not amenable to supervision at all. At age 25, Smith has 10 prior criminal convictions, counting these 2 today, and 9 prior juvenile adjudications for crime. That's 19 convictions or adjudications over only 13 years. When you go down and read through that sentencing, what do you see? In the criminal cases, you see probation ordered every single time, 8 times convicted prior to today. Smith was given 8 orders of probation. Smith has persuaded adult courts to place them on probation every single time. 8 times Smith has been ordered, to work with agents, to deal with substance abuse, to deal with mental health, to deal with cognitive issues. 8 times it's failed. CCAP and MCRO are useful in figuring out why. And that's because Smith simply doesn't participate unless they're physically forced to. MCRO and CCAP show countless failed court appearances while the cases are ongoing and probation violations once they've concluded. Smith's own stated reason in our case for fleeing the police was to avoid those consequences. Smith had 3 different Minnesota warrants out for her arrest when this fleeing happened. In our own case, even, it took 4 warrants across 3 years to force Smith here to this table at this moment. The court gave Smith a big leap of faith when it allowed her to stay out and go to that treatment facility while waiting for the PSI. And Smith demonstrated why she's not amenable to supervision when she didn't come back when she absconded. As a result, probation is not appropriate for this offender. There's no reason to think that she will comply when there's a decade of history telling us otherwise. Smith needs treatment, and this needs to happen in a confined setting. I find it strange that Smith related to the PSI writer that they didn't believe incarceration is effective at changing people's behavior because, like I said, Smith's effectively been on some form of supervision for 13 years, going way back into her childhood. She's not been given incarceration. So to conclude it's not effective when what you're asking for has itself not been effective doesn't make a ton of sense. It should be no wonder that Smith has continued unabated in her behavior because she's simply not been held accountable. The only time she's gotten incarceration, it's been as a revocation or a DOC action for noncompliance. The PSI talks about some of Smith's challenges, her criminogenic needs. Smith has a family that has a lot of members who have been involved in criminal activity. She talks about that in her own, how that's affected her own struggles in the PSI. She grew up with said family and said that they made drugs available to her, causing early life addiction issues that continue to this day. She has mental health struggles. At 25, she's seemingly not ever worked a job ever. These are all things that can and should be addressed when considering the character of the offender. These are obvious things that need to be dealt with to deal with the idle hands issue that I think is a cause of a lot of this crime. Those issues should be dealt with though in prison though, because prison does have resources that Smith hasn't tried. Being on supervision one way or another for 13 years in Minnesota, where they have far more programs than us, she's exhausted everything. Even beyond that though, there's profound need for deterrence and punishment in this case. To me, the number one thing I look at when I'm reading a PSI is the offender's version of their prior history. What a person thinks about what they've done in the past and how they talk about it now in the present tells you a lot about them. It tells you what is important enough to them to remember that they talk about later, how it affected them. This tells you about cognition. It tells you about criminal thinking. It tells you about consciousness of guilt. It tells you how they're going to think about this case in 5 years and 10 years. To the defendant's credit, she does appear to take responsibility for without making excuses of her adult criminal history. That's more than we can say for a lot of the people that come before this court. However, the defendant claims they don't remember any of the incidents that happened when they were a juvenile. I find this concerning for 2 reasons. One, that juvenile record was not that long ago. This defendant's only 25 years old. It was not, it was too long ago was not a viable excuse for not remembering. However, the main reason I'm really concerned about this is because Smith's juvenile record, I'm sure the court's noticed, is categorically different from her adult record in that the juvenile record is mostly victim cases. It's assaults, it's thefts, it's crime damage, it's arson, offenses where those should be the ones you do remember. Those are the ones you hurt somebody either physically or financially or emotionally. Those are the ones where if you have empathy and consciousness of guilt, you relate back, wow, I did this terrible thing to that person, that hurts, I want to change who I am as a person. Not these fleeings or a simple possession or something like that. There's indication in multiple places in the PSI that Smith would want to address issues and change herself, but none of those really seem to be in connection with remorse or feeling bad. They seem to be connected to improving her own experience in her own life. Looking at page 10 in the PSI, the defendant says she expresses remorse, but only talks about wanting to achieve better outcomes in her own life in terms of rehabilitation. To that end, what is left when you have a person who's been supervised constantly through various forms of adult and child supervision over a decade and it continues to fail? You do incarceration. That's what Minnesota finally did after many years in their most recent probation revocations. According to the PSI, if the court orders incarceration upfront in this case, it'd be the first time ever that any court has done so in Smith's life. The only time she's ever gotten any sentences, like I said, been on the revocation or been on some sort of a hold while waiting for treatment or something like that. It'll only be the second time she's ever been ordered to prison. It is unfortunate that Smith's been allowed to accumulate this kind of history in Minnesota. It would defy the sentencing factors in Wisconsin for a person to accumulate this many convictions and not get any incarceration. And the Cleary-Gallion factors wouldn't allow it. These cases and what these convictions are for and the non-appearances all reflect a deep cognition issue that doesn't really get addressed in the defense sentencing memorandum at all. The defense sentencing memorandum really just talks about substance abuse and another issue, which I'll get to later. When treatment fails, when cognition is contaminated with what I kind of view in the PSI and the offender's version of, what happened and what to do next and what their goals are, it reads like me. It reads like somebody who isn't thinking about rejoining society for the purpose of helping others or feeling bad about the victims in their cases. To that end, that's why you need specific deterrence in cases like this. If you have an offender where those drivers that we usually rely upon for people to modify their behavior, empathy, consciousness of guilt, just feeling bad for your own actions is how I describe them. Those things you hope that get instilled in children at a young age. When those aren't happening, when they've already had all the attempts being on supervision, whether probation or court supervision, where they've had the option of going to treatment centers and having doctors and having agents with them to work on them to accomplish conditions of supervision, when that just fails over and over, that's when you need specific deterrence. That's when somebody isn't being motivated by the carrot, so they need to be motivated by the stick. And this is one of those cases. It also leads me to general deterrence and punishment. As I said previously, this is the third time that Smith has been either convicted criminally or adjudicated delinquent of fleeing. This fleeing involved throwing large objects into the road. One of them was described to me by Deputy Moe as like a metal ramp that sparked as it hit the road. Deputy Moe said that Smith threw it into the middle of the road and he had to make an abrupt movement to avoid it. If he had made a mistake, if he had not reacted quickly enough, one of these objects could have been struck by him or a different police officer at the speeds they were going. They could have died. That's the essence of what the reckless is. The reckless is creating a risk of death or great bodily harm. In this case, it was to a police officer just doing his job, trying to arrest Smith on a warrant that resulted from her own behavior, from not cooperating with supervision over in Minnesota. Smith admitted they were fleeing to avoid consequences and said she was high on meth while fleeing. That reckless conviction exists because the way Smith chose to go about fleeing this time was so much more dangerous than a typical fleeing we see in this county, than her past fleeings. Other people in the public have to be deterred, and quite frankly, the need for punishment is the reason why the recommendation here for a high-end fleeing sentence and a mid-range reckless sentence is being recommended, because the gravity of this offense, the way the reckless and the fleeing exacerbate each other, aggravate each other, is the reason why. This was a fleeing where the driver's speed was high. It varied between 40 and 69 miles per hour, where Smith would only slow down when throwing objects out of the vehicle. She blew stop signs. She crossed the center line. The vehicle only stopped because Smith disabled it herself while trying to get into the ditch to avoid a spike strip. Smith fled on foot afterwards after the vehicle wouldn't move anymore. Chase was over 10 miles. And it's a chase that endangered the deputies, as I described before, with the throwing of objects. This is not a young first-time offender who made a one-off mistake, who acted outside of character because of some underlying issue that heretofore has never been addressed before and is easily fixed. This is a 25-year-old person who has, despite 13 years of some help, some supervision, some court conditions, has continued to be a risk to the community, has been escalating in the risk to the community with this fleeing, who continues to ignore supervision and rules of courts. The courts have uniformly given Smith up to this point second, third, fourth, eighth chances, and now Smith is asking for a 19th one if you count the adjudications. McCleary-Gallion factors demand more. The character of this offender is such that prison is necessary. Probation would unduly depreciate the seriousness of this offense, and the court should follow the recommendation of 1.5 in, 2 out on the fleeing, and 3 and 4 out on the reckless. Finally, there's one thing I do need to comment on from the sentencing memorandum that I have a serious problem with. The defense sentencing memorandum makes arguments that use the defendant's gender as a basis. That memo argues prison is not safe for transgender people, that prison cannot allow Smith to navigate her gender identity. That I have 2 main responses. One, it is ridiculous and without evidence that the Wisconsin prison system cannot accommodate transgender people. It can and it does. The prisons are safe, probably safer than outside the prison because of all the supervision and control of inmates. This is a perpetuation of movie stereotypes that is wrong and harmful. Second, it's illegal for courts to consider gender as a sentencing factor in Wisconsin. It is categorically an improper sentencing factor, just like race or religion. The Supreme Court of Wisconsin explicitly held that gender cannot be considered in State v. Harris, 2010 WI 79. Any argument based upon Smith's gender should be disregarded by this court. It has no application to sentencing in Wisconsin. Thank you.
All right, thank you. Mr. Felicki, before I ask for your argument and recommendation, what is the jail credit?
Thank you, Your Honor. I have the following totals from a review of this file. It appears that initially Josie Smith was brought into custody on May 2nd of 2023, then posted cash bond on May 9th of 2023. She would have 8 days of credit from that time. She was then brought in on a warrant. I believe that was served and executed on January 31st of 2024. I then note here that bond was posted on February 5th of 2024, making for 6 days. Lastly, she has the current period of incarceration that she's been serving from May 26th of this year up until today's date, which would be, by my math, 69 days. So all told, by today's date, she would have 83 days of credit. I've relayed and discussed this with the state, and I believe that is the party's stipulation.
Yes.
Okay, thank you. And it's my understanding that Josie is still on supervision from the latest Minnesota conviction from June?
I believe so, Your Honor.
At least that's what the PSI is stating, and no one corrected me. All right, thank you. Argument and sentencing recommendation, please.
Thank you, Your Honor. I think certainly when we look at this situation, it is quite serious. It would be quite serious if it was a first-time offense. It is certainly serious as it is now. It involves a high-speed chase with law enforcement over several miles, at which point several items were thrown out of the window. It is serious. And I don't think that Josie is under any impression otherwise. In discussing this case with her, Your Honor, and discussing this sentencing, it's been very clear, been made very clear to me that she understands that this is the last stop. There are no further chances that are going to be coming after this. Her record is quite long. It involves serious offenses. It involves offenses of a repeated like nature. She understands that after this point, frankly, since she's been an adult, and arguably before, there are responsibilities towards participating in society that she has not upheld. She's engaged in antisocial behavior and has received punishment to that effect. She has been put on supervision, as has been noted by the state. She has been revoked off that supervision multiple times in Minnesota. In fact, in looking through the packet and looking through the length of this case, it seems there were some significant periods of time in which she was serving out revoked sentences in Minnesota. I say all that, Your Honor, because I think the state's perspective on Ms. Smith is that she's someone that doesn't get it. She's someone that hasn't been able to get it. But in speaking with her and in discussing this case with her, Your Honor, I do believe that thankfully now finally has come the time where she understands that this behavior cannot, should not, and will not continue. She understands and is very open to me about the remorse that she feels for the situation. It's regrettable that it ever got to that point to begin with. But I think looking at that situation, Your Honor, and then looking at Ms. Smith's adult history, I think there is a clear through line here, and that clear through line is substance use. She's advised, and as was outlined in the defendant's memorandum, substance use has been a factor in Josie's life from a very young age. She was exposed to and given substances by people that she should have trusted. And I say should have trusted, Your Honor, because these were not people that she actually should have trusted, but she should have been able to trust them because these were people in her life, authority figures, family, who should have been there to look out for her, to look out for her going on the path that has led her up to this point and acted to steer her away from that. Now, I certainly don't think that that makes for an excuse, Your Honor. I don't think that that justifies what happened here or what has happened in the course of Ms. Smith's life. But I do think when we look at her character, her conduct overall, the reason that she is coming back before the court, that she is having difficulties in adjusting to supervision, the reason that she is getting new court cases is because of this underlying issue. I think thankfully, Your Honor, this last period of incarceration has in some ways been a blessing for Ms. Smith. It has been a period of enforced sobriety for her. It's been a period where she's been able to clear her mind and really understand the gravity of what has happened here, the gravity of what's occurred over the course of her life in this case so far, and what she needs to do to avoid that going forward. As a member of the Mille Lacs Band in Minnesota, Your Honor, Ms. Smith is, again, in somewhat of a lucky position. She has access through her connection with that community to resources that frankly make the resources that someone else in that community pale in consideration. There's simply more funding, more programming that's available for her as a member of that tribe. So I think looking at the situation overall, Your Honor, looking at the reason why Ms. Smith keeps on coming before the court, the reason why she keeps having these issues in adjusting to supervision is by and large from an inability to address and move forward from an issue of substances with narcotics. While there is certainly programming available in the state prison system, Your Honor, it, I would say, pales in comparison to what is available and accessible to Ms. Smith when outside of custody. Excuse me. I'd also note that, frankly, in looking at Ms. Smith's history, looking at her connections to this area, to Brant County in particular, what I have noted and noticed is that she is by and large, a resident of the state of Minnesota. She has connections in that state. That is where her support network is located. That is where she has built her life, so to speak. I think creating a connection here with Wisconsin, Your Honor, would perhaps be a mistake, given that she has built up this connection, this relationship with her home state, such that presumably the ability to access the resources that she does need to address would simply be much more straightforward. So I think looking at the situation overall, Your Honor, while I do understand the hesitation regarding the history here and the severity of the offenses to probation, frankly, I think that frankly, she's a good candidate because of these underlying needs, because of the fact that she has this clear issue, I would say, with addressing and maintaining her sobriety and proceeding down for recovery. So based on that, Your Honor, what I'm asking the court to do is to sentence Ms. Smith to a period of incarceration in the jail for 110 days, with eligibility for good time, on both counts here, concurrent with each other, consecutive to any other sentence that she may be serving. Thank you.
All right, Josie, I see that you have a paper and it looks like to me you wish to make a statement and you wish to read off of that statement. Is that correct?
Yes, Your Honor.
I'm going to ask you that if you are going to read a statement, first off, Mr. Flisky, please make sure that the microphone is closer to Josie's mouth. Second of all, Josie, please speak loudly, enunciate your words, okay? You need to speak slowly as well because my court reporter needs to take everything down, okay?
Okay.
Also, before you proceed, what is your contact, your relationship with Burnett County?
I have some family here, but not a whole lot. It's on my mom's side, but I don't have much connection to Burnett County.
So family, you mean close family members or just distant family members?
Distant family members.
And so you don't see them very often, if at all?
No,
You have no reason to come into Burnett County?
no,
So if the court were to say no contact with Burnett County, you would not have a problem with that, correct?
no, I would not, Your Honor.
All right, Josie, continue.
Dear Judge Mogan, I'd like to start off by saying how sorry I am for my part in taking so long to realize how much time it's taken to get this case settled. I realized that I've made so many mistakes that I cannot change, but learn from it. I've been so hard on myself, and I know that just because of my past doesn't mean it's too late to change my future. I have so much to live for and do with myself instead of repeating past behaviors. I've learned that no one will or would judge me if I have to ask for help. I've always thought about others. People treated me different if they saw or knew that I needed help. But truth be told, it shouldn't matter to them because they don't know my whole story. And it doesn't matter what they think. I struggle and I struggle, but knowing or by thinking I know how to help myself, I didn't. I know now that maybe it's better if I get help from someone professional, or just maybe I can have the chance to get a better outcome. I've had some time to think of a plan for when I get out. I have plenty of resources and structure and people to stand by me and help me get through this that I didn't realize I had, and I don't have to go through this alone. I also understand that this is a serious and take full accountability for my actions. I didn't intend on hurting anyone, but by my actions, I do see now that I could have, anyone including myself could have been seriously hurt. I don't like knowing that I was the person putting others in danger. I hope you know that I'm really sorry for my actions in putting the police officers and myself in danger. I've learned a lesson that by the path I was going down would not end well for me, and that it's not too late to take a better one. As soon as I get out, I also plan on seeking help for my mental health. For my depression, I plan on seeing if there are medications that can help with my mental health. I know that things like medications take time to start working, but I like to start somewhere. I made a few phone calls to get into a program called the Anjibin Magazine. Provides.
You just repeat that, please, and very slowly, because I'm not sure if I'm hearing it correctly, and my court reporter does need to make sure she understands as well.
Angibimadizine. It's spelled ANJ.
I have it. It's a double A too. I'll tell
Okay.
court reporter how to spell it.
Okay, sorry. It provides sober living, work options, treatment options, and helps with college options. All that can help with my journey on recovery that will be beneficial for me. I'm planning on getting a Rule 25 as soon as I'm released. If I have to cut people out of my life that aren't fit for my journey, then I'm willing to do so. I just want to do right, and I want to prove to myself that I can do it.
Thank you, Josie. Is your address still in Grace Lake Road?
Yes.
Is that a parent's address?
Yes.
All right. Okay. I have reviewed the pre-sentence investigation report and the sentencing memorandum that has been provided by the defense. I have been struggling with this case, Josie, simply because you had your initial case, the 22 CF 120 case, which was serious enough. And then a year and some down the road is when you engaged in this conduct, very serious, dangerous conduct. And you received all of these charges, 10 actually, 8 felonies and 2 misdemeanors from the conduct on May 1st, 2023. The most frustrating part about your case, Josie, not only that you engaged in this kind of conduct to begin with, but there's those underlying issues that the court and other parties can understand, the substance abuse, okay? But the most frustrating part is how you would come to court, then you abscond and go away for a long period of time. Then you'd come back and say, Judge, I'm going to be better. I want to work this out. And then you'd disappear again. And then you'd come back and say, Judge, but really this time I really want to. And then you'd go and you disappear again. And this is we're dealing with a 2022 case where it initially started. And the 2023 case, we're dealing with cases that are 4 years, 4 years old that should have been resolved a long time ago. They were way back in the beginning. It's just that something would happen and you would flee or you'd go abscond and you go engage in this other kind of behavior. Lucky for you, you didn't rack up a whole another sheet of crimes. I mean, there was a lot in there from the time that you were charged with our cases. But hopefully you're on your path to figuring it out. Because if you don't, with all of the things that are going on, Josie, both what you're displaying outwardly, but most importantly, what you're feeling and going through inwardly, it's going to destroy you. You have to work through those, and you have to start with going to the healing center, working through your traumas, discussing what you are experiencing and feeling today as Josie, all right? And that kind of situation before you can change yourself. And you did hit it, the hammer right on the nail when you were stating that, you know, maybe I can change the people that I hang around with, and I probably should. Because Josie, you have to change your habits and the things that you do, and you have to change your associates, the people that you hang out with, in order so you can change yourself. You have to be able to do that. That's where you start, changing your habits and the things you do, and changing the people that you give yourself to, you give your time to, your energy to. That's the only way you're going to significantly improve your life. And if you don't modify and make those changes, I hate to see where you're going to be in 5 or 10 years. I hate to see that. The court has to look at the seriousness of the allegations, the nature and gravity of the offenses here. And the court looks at all of the charges that were dismissed and read in, including the charges that you were convicted of, and to see whether or not there's an aggravation there. And there is with all of these felonies and all of these serious crimes and the conduct that you engaged in, it does aggravate it. I have to look at your character, your past criminal record. I have to look at needs for your rehabilitation and protection of the public. And as Mr. Schmidt touched on, I have to look at this thing called deterrence. So what sentence is going to finally deter Josie from continuing down this path? And what sentence is going to deter others from doing similar things? Because if the court were to look at a lesser sentence, a smaller sentence than what's recommended here, well, let's say a very small sentence. We'll start at the short end of what defense argued, 110 days, concurrent with each other, but consecutive with any other sentence. If the court were to look at a sentence structure that is that small with the actions here, it would unduly depreciate the seriousness of the offense, and it would not deter others from doing this. Because if we look at this, the charges alone that you pled guilty to and you're convicted of, that was extremely serious. Speeding down a roadway, a highway in Burnett County, and throwing things out of the car to try and evade and flee the officers. Where Mr. Schmidt made a very good point that if something were to be thrown out of the vehicle and were to hit the officer's car going at a high rate of speed, anything could happen. The officer could swerve and hit a pedestrian, could hit a different vehicle, could hit a house. The officer could die. Innocent people could have died because of your actions and conduct that day. So that's where the court has to look. Are we looking at a punishment in the lower end, or are we looking at the higher end of a sentencing? This is serious. And it should deter not only you, but it should also deter others from thinking that this conduct and this behavior and doing these things is okay. The court will not look at probation. I have looked at it first, but I will not order probation because, as I stated, it would unduly depreciate the seriousness of the offense. So the court has to determine, is this going to be a straight out jail sentence, or is this a necessary prison sentence where you need more structured supervision and someone else from Minnesota, because you're not from here, so you would be asking to have through the interstate compact your probation or extended supervision in Minnesota, but to have somebody else oversee you to make sure you're doing what you need to do. Josie, you're in the driver's seat. You're in control. You have to make those choices and those decisions. You have to. You are at this age where your brain is finally starting to fully develop, and you're starting to be able to think like an adult. You have to now start thinking clearly. Is this where you want to be in 2 more years, Josie?
No, I
you
don't.
don't. Is this where you want to be in 5 years or 10 years? Or is this where you want to see your friends or your family in something in a chair right there,
No, I
waiting
don't.
to determine if you're going to go to prison?
No.
In front of the court, you have appeared that you have a kind and gentle soul, demeanor, but you are letting your internal demons destroy you. You are. I do understand you've had a lot of trauma in your life. I've read it in the black and white, and I've heard some from you throughout these years. You can't let the trauma continue to dictate and to control your life. You have to do that. You do need some kind of treatment. And you do need to take that seriously. But again, only you get to make that choice. I have to look at protecting the public. And here, quite honestly, in my view of protecting the public, it's protecting Burnett County, the residents of Burnett County, and then I guess bleeding over to all of Wisconsin or there. And I know you have connections with Sawyer County, you have connections with Burnett, probably through family in both areas. but I do need to look at protecting the public. And so that's where the juggling comes in of, do I look at a lesser sentence or do I look at all the way to the maximum possible penalty? But I have to look at a sentence that is minimal enough to deter you and to look at the seriousness of the crime without going beyond and being too harsh. Now, in reading the pre-sentence investigation report and hearing the argument of the state, it makes a lot of sense. Look at what you've been doing. You have continued to engage in these serious crimes. You've been to prison. You're not being held accountable. You're not taking responsibility. You continue to let your life be taken over by other people and their choices instead of making your own choices. So a prison sentence makes sense. However, there are other factors here as well. Your attorney did hit on some good things that you are finally in a place where you're realizing that you need to do something, or God forbid, you won't be around if you continue to engage in this type of behavior. Prison would be the least of your concerns. I don't want to see that, Josie. I don't want to see that. So I am looking at the middle ground of a sentence, something that would protect the public. It would address the seriousness of these offenses. It would look at your character and your past criminal needs and look at your need to rehabilitate, all right? And look at you as an individual person. So based upon that, what I am believing is an appropriate sentence. I don't believe that you need to have any continued contact with Burnett County. You don't need to have contact with Wisconsin. You can live your life and do what you need to in Minnesota, but you do need to be punished for your conduct and your behavior involved in this case and the 22 case. So what I am going to do is I'm not sending you to prison. So this is a blessing to you, Josie, right now. It is a blessing because you're going to get the punishment factor and the sanction factor, but you're also going to be able to figure out a life plan and follow that yellow brick road to what it is that you want to see your life be and for you to become. But I do think it is serious enough to sentence you to 1 year of jail, of county jail. Okay, 1 year. There will not be any ability to have the electronic monitor because I don't trust you. Sorry, I don't. And you're shaking your head up and down like
I understand.
it's fair, right?
I understand.
So 1 year in the county jail, that gives you enough time to sit and to think and to figure it out. And it is consecutive to all other sentences. And it is each charge, each count has 1 year of jail concurrent to each other, but consecutive to any other sentence that you would be sitting, okay? $518 in fines and fees. I am also going to do a punishment factor on the financial end of it. $1,982 for each count in a fine. Because you failed to come to court, you failed to take care of this and handle this, and you missed court and absconded and were in custody somewhere else when you shouldn't have been, and the court did not even have to allow you to appear by video. But I believed you, Josie, when you said you want to make these changes and you want to do better. I believe you. But you have to grasp that hard and you have to take control and ownership of it. I can't want it for you more than you do. Mr. Felisky can't. No one in this courtroom can want it more than you because you're the one who has to do it. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. No use or possession of a firearm for life, no voting in any election until your civil rights are restored. That does not include tribal elections. You have to speak with your tribe if you are having an election, whether or not they would permit you to continue to vote. I believe a lesser sentence would unduly depreciate the seriousness of the offense and it would not protect the public. And it's a punishment portion, I believe that covers everything. Mr. Schmidt, what am I missing? Oh, 89 days of jail credit, 83 days of jail credit. No contact with Burnett. Don't come to Burnett, okay? Because if you're not doing well, I don't want to see you again.
I don't plan on.
But I want to know if you're doing well, okay? So, Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Felisky?
Nothing further. Thank you.
All right, then we are adjourned. Thank you.
Thank you.
Mr. Kisslinger, why should I not issue a warrant?
Well, because I wasn't sure. I fell asleep. I went on my cat and big bowl of chili.
That's not a reasonable excuse. Lucky for you, your attorney argued very zealously on your behalf, and I didn't issue a warrant, but you are coming back on Thursday at 10. Thursday at 10. Oh, I even said the wrong time. I wanted 10:45, but.
I have a notice of hearing.
Okay, come get your notice of hearing. We will go on the record in the matters 26 CM 79, 26 CM 85, State of Wisconsin versus Heather Larson. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Felisky, Defense Counsel in person. Ms. Larson appears in person in custody. We're set today for status conferences. Mr. Felisky, please update the court.
Thank you, Your Honor. Previously, I had raised competency regarding Ms. Larson. I believe that was at the initial appearance that had been scheduled for both of these cases. At the time, I was concerned about her ability to understand the proceedings and or assist in her own defense. I see that a competency evaluation was conducted. A report was then filed on the 16th indicating that Ms. Larson is in fact competent. I reviewed that report with her and I believe we are stipulating to that finding. I have had an opportunity to review the complaints in full with her, Your Honor, if the court would allow. I believe we could conduct a initial appearance on both these cases.
All right, thank you. Anything you want to add before we proceed, Mr. Vila?
No, Your Honor.
The court has received and reviewed the report evaluating Ms. Larson's competency. Mr. Felisky, along with Ms. Larson, are stipulating to the competency based upon the facts. The court is taking judicial notice of the report based upon the facts and the conclusions in the report. The court does hereby find that she is competent to proceed and to assist in her defense. With regards to both of these cases, were you able to go over the criminal complaints with her, and does she understand those counts and those maximum penalties?
Yes, Your Honor. I did receive and review both complaints in both cases. I have provided Ms. Larson with copies of both and have reviewed both complaints with her, both the charges and the probable cause section. I do believe that she understands the charges here along with the maximum possible penalties for both complaints and for all counts. We will waive formal reading and to all counts, and I believe they're all misdemeanors, but to all counts at this time, we will enter in a plea of not guilty by reason of disease or defect.
Court will enter not guilty, an NGI plea on her behalf. Are you still located when you're not in custody on Park Road?
Jensen Road,
Okay.
the same park though.
Okay, can I get your address, please?
23405 Jensen Road, lot 38. That'll be with Chad Campbell.
Okay. And when you're not in custody, does your telephone end in 0152?
I do not have a phone, but I can give you Chad's number.
Okay.
715-431-1718.
All right. May we send it text messages?
Yes.
Okay, thank you. Okay, not guilty pleas by reason of mental disease or defect has been entered on your behalf. You do need to set some status dates and times. I could do September 24th. at 10:30.
That time will work for my calendar, Your Honor. I do want to just put on the record very briefly. I have discussed with Ms. Larson this case. I believe there will be a bond motion filed after today.
Okay, thank you. All right, we will see you then. We are adjourned.
Okay.
Is this Mr. Cote?
Yes, there is.
All right, thank you. We will go on the record in the matter 26 CF 40, State of Wisconsin versus Devin Cote. The state appears through Assistant District Attorney Jose Vila in person. We have Emma Hanu, Defense Counsel in person. Mr. Cote appears by telephone conference with approval of the court. We're set here today in this matter for a status conference. Ms. Hanu, please update the court.
Thank you, Your Honor. Following our last hearing, an offer was presented. I was able to go over that with Mr. Cote. He was not at present amenable, but I have been talking with the state and we're working on some negotiations. So at this time, I'm just asking for another status to give us time to see how and what we can shake out.
What was the offer that was presented?
The offer was presented to plead to 3 counts of felony failure to support for 3 years of probation.
All right. Let's get a status, date, and time. I just realized I put the last case on the wrong week. Okay, can you do September 28th at 10:45?
I cannot.
How about in the afternoon?
The afternoon would work.
1 o'clock?
That'd work for me.
1 o'clock, September 28th. You may appear by telephone as you've done here today, okay?
All right.
All right, thank you. We'll see you then.
Thank you, Your Honor.
You are muted. I'm asking you to unmute. I hit a button. Can you see it? You are still muted. There you go.
I missed that. I just downloaded the app, so it's kind of asking me all the permissions and all that. So,
Okay, that's okay.
uh,
All right, we will go on the record in the matter 26 CF 87, State of Wisconsin versus Tyler Merle. That's right. It's Merle, not Merrill, correct?
yes, miss.
Mr. Merle. He appears by video conferencing with approval of the court. We have his counsel, Emma Hanu, in person, the state through Assistant District Attorney Jose Vila. We're here for a preliminary hearing. However, I have received a document signed a waiver preliminary hearing. Did your attorney go over that document with you, Mr. Merle?
Yes, Your Honor.
And so you understand what a preliminary hearing is?
Yes, Your Honor.
And is that your signature? Did you sign that document?
Yes, miss.
Do you understand that once you give up the right, it is forever and you can't get it back?
Yes, miss. That's just yes, miss. Yes, miss.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, Your Honor.
You're doing so freely and intelligently, letting me know you do fully understand what you're doing here today.
Yes, miss.
Do you understand that once you give up the right, it is forever and you can't get it back?
Yes, miss.
I will find that he is competent, he's freely, intelligently, and voluntarily waiving his right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Vila.
Thank you, Your Honor. I'm filing the information currently. It will mirror the criminal complaint.
Proceed with an arraignment or set it for another date.
Proceed with arraignment, Your Honor. We'll enter a not guilty plea to count 1 and count 2. We will not be exercising the right to judicial substitution.
All right, not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. September 28th at 1 p.m. I think. Let me just double check. September 28th at 1 p.m. We will have your status conference. If you're still at treatment, you may continue to stay there, okay?
All right, sounds good. I appreciate it. Thank you.
All right, thank you. We are adjourned.
Thank you, Your Honor.
Thank you. Ms. Nimmo and Mr. Chapman. We will go on the record in the matter 26 CF 93, State of Wisconsin versus Brittany Nimmo. The state appears through Assistant District Attorney Jose Vila in person. Ms. Nimmo appears in person with counsel Daniel Chapman. We're set today for a preliminary hearing. Mr. Chapman, is it proceeding as such?
Yes, Your Honor.
All right, Mr. Vila, you may call your first witness.
Thank you, Your Honor. State calls Chief Trevor Tex.
Chief Tex, please come forward, raise your right hand. You'll be sworn in, have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
I do.
You may begin.
Can you please state and spell your name for the record?
Trevor Tex, TrevorThiex.
And how are you currently employed?
The police chief for the village of Siren.
And how long have you so been employed?
As the police chief, this will be year 4, so like 3.5 years, total in law enforcement, like year 24.
So prior to today's hearing, did you review a criminal complaint in Burnett County case 26 CF 93 as it relates to Brittany Nimmo?
Yes,
So on June 16th of 2026, did law enforcement conduct a traffic stop near the trailer park near Clear Lake Park in Siren?
yes,
Is that in Burnett County?
yes,
Did they make contact with the occupants of the vehicle?
yes.
Who was in the vehicle?
Brett Frank was the driver and the passenger was Brittany Nemo
And how was Brittany Nimmo identified?
through, I believe it's prior police contacts.
Now, have you yourself ever seen Brittany Nimmo?
Yes,
You know what she looks like?
yes,
Do you see her sitting here in the courtroom today?
yes.
Could you please identify her by where she's sitting and what she's wearing?
She's seated next to her defense counsel. Looks like a black t-shirt, not a t-shirt, but like a tank top.
Court will state that Chief Tex has identified Ms. Nimmo.
Okay. Now, was the vehicle in question searched?
Yes,
Was anything found?
yes.
What was found?
The driver, Mr. Frank, admitted to a bong in the center console. So that was located. There was other items of paraphernalia in the center console as well. There was a gem baggie located under the driver's seat that was empty. There was a bag on the front passenger floorboard that had one empty gem baggie, one gem baggie that had 0.51 grams of a crystallized substance, which later tested positive for the presence of methamphetamine. There was, I believe, 8 pills. I can't remember how to pronounce or know how to pronounce the name of what type of medications they were, but they were pills that needed a prescription for.
Okay, so that gem baggie that was found, where was that located again?
In the bag on the floorboard of the passenger front seat.
And who was sitting in that passenger front seat?
Brittany Nemo.
No further questions, Your Honor.
Mr. Chapman, questions?
You said you know Miss Nemo. Did you verify in any way that the person you're looking at here today is the same person that was dealt with by other officers on the day you're describing?
Just went off of the criminal complaint and the police reports.
So you read a name and this is the person you know as that name?
That's the person I know as Brittany Nemo, yes.
No further questions.
All right, any redirect?
No, Your Honor.
All right, you may step down. Thank you.
Thank you.
Any further witnesses?
No, Your Honor.
Mr. Chapman, any witnesses?
No witnesses for today.
Any argument?
Well, I know we've been over this many times, but this officer saying, yeah, I know that person does not connect the dots to what happened that day. He should look at a body camera for booking photo of the person that was arrested or talk to the officer in question, but there has been no connection made between this identification and the hearsay testimony he's relaying.
Mr. Vila?
Your Honor, at preliminary hearings, evidence goes in line in favor of the state. Chief Tex identified Ms. Nemo from prior police contacts himself. That should be sufficient.
I do understand where your argument lies, Mr. Chapman. But because of the low hurdle, court will find there is probable cause to believe a felony was probably committed by Ms. Nemo. The court will find the probable cause and will bind the matter over. Information, Mr. Vila.
Thank you, Your Honor. I'm going through and filing the information as we speak. It will mirror the criminal complaint.
Proceed with an arraignment or set it for another date.
One moment, Your Honor.
You hear me?
I can, Your Honor.
I do not have Mr. Kisslinger, so I'm not sure if I'm missing something or if he's just not here.
He might be running a bit late. I guess I'll reach out to him and see if I can get him in.
All right, that tends to be his problem. He's usually a few minutes late, but do you want to quick try and give him a call? I'd appreciate it.
I will. Thanks. Yes, Your Honor.
We're able to get a hold of him.
I was able to get a hold of him. I had spoken to him earlier today. He told me he was on his way. He told me he was leaving his house, so I don't know how quickly the turnaround that would mean, unfortunately.
Well, I'm going to call the case, and whether or not I issue a warrant, I'll wait and see, but I do need to get going. I have a very serious sentencing next, which is, this one was double booked with my sentencing because it was supposed to be something quick and easy.
I understand, and apologies for that, Your Honor.
We will go on the record in the matters 26 CM 05 and 26 CM 50, State of Wisconsin versus David Kisslinger Sr. The state appears through Assistant District Attorney Jose Vila in person. We do not have Mr. Kisslinger. His attorney, Peter Vu, is by video conferencing. He was able to contact Mr. Kisslinger by telephone. He's on his way. How close he is to the courthouse, I am not aware. This matter was scheduled to start at 1:07 p.m. or excuse me, at 1 o'clock. It is 1:07 p.m. at this time. It was double booked with a felony sentencing case due to the fact that the court was informed that this would be a short and quick hearing. We do not have Mr. Kisslinger. The court is viewing all of the building's cameras, and Mr. Kisslinger is not in the building or near an entrance or exit of the building. Mr. Vu, please update the court. Where are we? Was he able to find a mental health evaluator?
Yes, Your Honor. I spoke with Mr. Kisslinger earlier today, which is part of why I suppose I'm a little confused that he's not here right now. However, he indicated to me that he has an assessment set for Wednesday of this week. So at least that is in progress. That's obviously directly related to the plea agreement that we have with the state. As unfortunate as that he's not here right now, I asked that perhaps we set another date, and I would ask that we not issue a warrant, given that, and perhaps at another date. And obviously, he may well appear later. And I did speak with him a second ago, as Your Honor notes, and he indicated he was on his way.
I can do 10 o'clock on Thursday.
This week, Thursday?
Yes. And I will be able to get an update. That's the best you're going to do without me issuing a warrant.
10 a.m. on Thursday would be appreciated, Your Honor, yes.
All right, Mr. Vila, anything you want to add?
No, Your Honor.
This does have victims, so would we be able to be in compliance? Yes. Okay. Thank you. We'll see you 10 a.m. Wednesday.
Thank you, Your Honor. Appreciate it.
Thank you. We're adjourned.
Thank you, Your Honor.
you understand what it is to have a preliminary hearing, whereas the state has the burden to prove a felony was probably committed and probably committed by you?
Yep.
Do you understand that by waiving your right to a preliminary hearing, it means you agree that the state can at least meet that burden?
Yep.
Can you say yes instead of yep, though, just for the
Yes.
transcript purposes? Thank you. Do you understand that at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses or call witnesses to testify for you? He'd also be able to produce evidence on your behalf or possibly discover things about your case, which could include defenses. But for today's purposes, you're giving up that right?
Yes.
Do you understand that if the state does not meet its burden as to the felony, I could amend it to a misdemeanor or dismiss it altogether, but for today's purposes, you're giving up that right?
Yes.
Do you understand that once you give up the right, it's forever and you cannot get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently. That means you're telling the court that you fully understand what you're doing
Yep. Yes.
and voluntarily?
Yes.
I'll find she is competent. She's freely, intelligently, and voluntarily waiving her right to a preliminary hearing. I will find probable cause and find the matter over. Information, Mr. Vila.
Thank you, Your Honor. I filed the information. It mirrors the criminal complaint.
Proceed with an arraignment right now, Mr. Fisher, or set it for another date.
Your Honor, we can proceed with the arraignment. Knowing that the information will mirror the criminal complaint, we would waive any further reading of the information. Ms. Marcian does understand the charges and the maximum penalties. We'll enter not guilty pleas to all 3 counts, and we will waive speedy trial and ask that this be set for a status so I can review discovery and discuss this matter with the state.
All right, not guilty pleas are entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. When not at the treatment facility, do you still receive mail at Wisconsin Avenue North?
Yes.
And your telephone would end in 4834?
Yes.
All right, may we send you text message notifications of upcoming hearing dates?
Sure. Yeah.
All right, I can do September 28th. I could do 10:45. Does that work, Mr. Fisher?
Yes, Your Honor.
All right, you may appear by video like you're doing here today, Ms. Marcian, okay?
Okay.
But only if you're still in treatment.
Okay.
All right, so we will see you September 28th at 10:45. Thank you. We are adjourned.
Thank you, Your Honor. Have a nice day.
On the record in the matter 26 CF 106, State of Wisconsin versus Sean Lindis. Mr. Lindis appears by video conferencing in custody in Burnett County Jail. I do have signed waivers of extradition in the file. Mr. Lindis, can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Do you understand that you are being asked to be extradited to the state of Minnesota, Chisago County, to face certain 5th degree possession charges?
Yes.
Do you understand that there is bail currently set at $20,000 Minnesota, but that only means $2,000 cash? Do you understand that?
Yes.
Do you understand that you have the right to an extradition hearing, whereas you can have the state of Minnesota as well as the state of Wisconsin make a determination with the governors to decide who has jurisdiction over you? You understand that? And do you wish to be voluntarily extradited to the state of Minnesota?
Yes.
Do you understand you have a right to an attorney
Yes.
and that you could fight the extradition process if you wish to do so?
Yes.
But you wish to voluntarily waive that right and be extradited to Minnesota?
Yes.
I know you can't see these documents, but they're waiver of extradition documents. Did you sign those documents?
Yeah, I guess I don't was I supposed to sign them?
No, yeah, that's, if you don't mind and you want to be extradited to Minnesota, you're supposed to sign them. Is that what you want to do?
Yes.
Excellent. All right, so that is your signature?
Yes.
Okay. Has anyone made any threats or any promises to you for you to waive your right to a formal extradition hearing?
No.
You're doing so freely and intelligently, telling me you fully understand what you're doing?
Yep.
All right, I will sign these papers and you will be extradited to Chisago.
One defendant's repeated mistakes pushed this courtroom to its breaking point. But what happened next showed exactly how a judge weighs justice, accountability, and the possibility of redemption. The sentencing hearing centered on Josie Smith, a defendant with a long criminal history who admitted guilt in a dangerous police pursuit case. Prosecutors argued that probation had already failed multiple times, pointing to years of missed court dates, repeated fleeing offenses, and countless chances that never led to lasting change. They told the court that this high-speed chase endangered officers and innocent people, making prison the only appropriate outcome. The defense didn't deny the seriousness of the crimes. Instead, they argued that addiction had driven years of poor decisions and that the defendant had finally begun accepting responsibility. They asked the judge to consider treatment instead of a lengthy prison sentence, saying this was the first time the defendant truly understood how much damage had been caused. Then came the most emotional moment of the hearing.